Afternoon and welcome. I'm Antigone Peyton, and this is Cloudigy Law's Everyday IP live stream show. I'm really happy that you've joined us today. We have a special guest with us. His name is Ernie Svensson, and Ernie is going to share with us today his journey from lawyer to author to blogger to digital educational maven and Ernie has agreed to use his life and the things that he has learned along his personal journey as he's changed his life and focused more on content creation to help us better understand the IP issues that people encounter when they create content. So with that, I want to welcome Ernie. Ernie, thanks for joining us on the show.
Oh, thanks for having me. It's great to be here.
So Ernie, I think it would be helpful for our listeners if you tell us a little bit about your background and what you've done in the past and all the things that you've published, because I think you've published a great deal of content at this point and have learned a lot through that process.
Sure. Yeah. Well, it was a ride marked by serendipity. It was not planned out. It was kind of just things just sort of happened. I call it the Mr. Magoo school of making things happen. Basically, I went to law school. I didn't know what kind of lawyer I wanted to be. I kind of wanted to be like Perry Mason or Matlock, and just have a limited staff and a simple operation. But when I got out of law school, surprise, surprise, I didn't know how to practice law. I didn't know how to run a law firm. I didn't know a lot of things. And so, fortunately, I did well in law school and I got a job offer at a big firm in New Orleans. Went to work there after I had clerked for a judge for a couple of years and basically just sort of figured out the ropes, did commercial litigation. It was a paper intensive practice. I relied heavily on paralegals. And so as I got more into the practice and learned how to practice and felt comfortable, like maybe I could start my own practice, I didn't really want to have a big staff. And so I one day discovered how to scan papers because a friend of mine showed me how. I learned how to become paperless. And then I also started a blog where, it was early years when there were supposedly only 5 attorneys with blogs. And that got attention. And so had some free marketing available to me, even though I knew nothing about marketing. But with those two wonderful serendipitous things, I was able to start my own solo practice, and I did commercial litigation and sort of figured out how to use technology to work, smarter, not harder, as they say. And that took me a little while to figure out, but I did. It was great. And then along the way, the ABA, which I had been going to speak at conferences about technology at the ABA, somebody from the ABA approached me and said, "Hey, would you like to write a book to show other lawyers how to set up and run a blog?" And I said, "Sure," because I had always wanted to write a book. And of course, like everyone, always intended to and had these grandiose ideas in my head, but I probably would never have done it. But when the ABA said, here, sign on the dotted line, write a book, and we'll help you, I figured if I couldn't write a book about blogging, then I was in serious trouble. So wrote a book about blogging, the ABA published it, and from there it took off.
Excellent. And so I think that was your first lesson we discussed in preparation for this show. So tell me a little bit about that process of working with the ABA and becoming an author under the ABA umbrella.
Yeah. Well, I mean, it was great. They knew what to do because basically they publish a lot of books and they work with a lot of authors, especially a lot of first-time authors. And so the folks that I had to work with me were really great. They guided me. And, I mean, in retrospect, I think a lot of what I saw as challenging was set up in my own mind. So basically, a lot of what they did was, assuring me that it wasn't going to be that hard and putting my mind at ease and so forth. And so basically, it was like writing a very lengthy brief. I knew the process of writing, I just hadn't written a book before. So I submitted it in a Word document, and they took it and made it look pretty and put it, and I took screenshots. I had to do my own screenshots, and they told me whether those were acceptable or not. And they basically just told me what to do at each step, and I followed their instructions. And in the end, there was a book published with my name on it.
So when you say a book published, you're talking about a physical book.
Yes.
Was there a digital publication of this same content?
I think probably there was, now that I think about it. The ABA did do a digital version. I think they sent me a PDF version, although it wasn't published. I don't know if it was published as a PDF or what, but it was a physical book. That's really what they were selling, and that's what I expected to see. And this was before, I guess, people were rampantly downloading books. So I guess it wasn't emphasized. So I actually really don't remember what the PDF, what the electronic version of it looked like. I know I had a PDF version ultimately, but I wasn't allowed to sell that or give that away. That was just for me to use for instructional purposes when I did seminars.
So that brings up an important point, and that brings us back to my world, the IP world and copyright issues. So one of the things that authors don't think about, particularly when they're first-time authors, is what rights am I going to give to a publisher, like a traditional print publisher, like the ABA, and what rights am I going to reserve to myself? And first time publishers tend to give away many more rights than they need to in order for the publisher to do what they want to do. So it sounds like you don't remember exactly what you gave to the ABA, but I suspect that you probably gave them uh, rights to the digital work, rights to a number of different media, and potentially rights to audio versions of the content that you created, so that you couldn't then turn around and create other types of works, or even maybe what we call in the copyright world a derivative work. So a new version of the book that you would then publish on your own. So one
Right.
of the things that authors really need to think about when they're going out and they're working with publishers is they need to have a clear understanding of what the publisher intends to do with respect to marketing and selling the book, and in what medium, if you will, they're going to do it. And the author, either on their own or with an attorney, um, clearly protects all those other rights that they don't intend to give away, because sometimes the language can be so broad in this contract that you've given away many more rights than you need to. And for your purposes, for instance, since you moved into the digital world, you may have said, "Oh, wouldn't it be great to sell a digital version of this, or even to give it away as a free something for the seminars that I'm teaching?" You may not have had rights to do that, even though the ABA wasn't selling a digital version, either because they thought you might be competing with them, or nobody asked the question when it was time to divide up the rights between you, the author, and the ABA, the publisher.
Right. Yeah, I really didn't, I didn't look too closely at the contract, although I should have, obviously. But it was the classic thing. And I think a lot of first time authors experience this. So like, oh my God, they picked me. I don't want to, nitpick. Let me just get to work and start writing the book. And I also didn't really think about those rights that you mentioned. I mean, I'm sure they even have the movie rights if they would make a movie about blogging for lawyers, which I'm sure they wouldn't. But I didn't really think about that. And really, I was just concerned with trying to finish the book, which I did. And it was only after I finished the book, and then I would do events and speak and realize, well, if I wanted to give the book away, I had to buy copies myself. And I would get them at a reduced rate. That was part of the deal. But I'd still have to pay for them. And I guess their model contemplated that, because there were some ABA authors that did this, that if I wanted to run seminars and try to make money selling the books live, the way I would do this would be to buy the books physically, the physical books, at a discount, and then sell them at the regular price and make money that way. But that wasn't really a lot of money. I mean, I'd make a few dollars at most on each sale.
Mhm. Another issue that authors encounter, and I wonder if you've encountered this as you continue to publish, is understanding when they might get certain rights back that they've given away. So this is common with authors who work with print publishers who are constantly churning through new books. So if something needs a refresh, for instance, and it's 2 years down the road and it's a hot topic that's always changing, one of the things that a lot of authors encounter is the publisher, they start to get less interested in putting their marketing money into the book. And the author might be interested in actually creating a new updated version or using some of that content for other purposes. But
Mm,
because they've given away all these rights, it sort of sits on the shelf with the publisher, and they don't have the ability to maintain a revenue stream with that content they've created. They basically have to leave it with the publisher and start from scratch in the future. Is this
right.
something that you've encountered as you're publishing and becoming more sophisticated in understanding how to deal with your work and the rights to your work?
Yeah, well, it was more so with the second book that I published with the ABA, because the first one was about blogging, and they turned right around after I finished that book and said, "Hey, do you want to write a book about using Adobe Acrobat software?" Because I had a blog that was solely focused on that. And I said, "Yeah, I'd be happy to do that." And that negotiation was a little better just because I said, "Well, I was actually planning to write that book on my own, and I really don't need you because I now know how to do this." And so they gave me, the royal treatment. They said, "We're going to give you the maximum royalty of 15%, and here's all this great stuff we're going to give you. And of course, we'll help you market it." And so I agreed to do it, mostly because I knew that my threat of publishing it on my own was kind of veiled, that I really still didn't feel quite comfortable with that. And so I went ahead and did it. And then after I had that book, that's when I realized that I was, for that one for sure, I was getting a lot more invitations to speak. And that was the one where I realized, yeah, I'd kind of like to be able to market this on my own. And in fact, Adobe Acrobat now is in a different version than the ones that I covered in the book. But if I wanted to do an update, it would be a derivative work, and I wouldn't be able to do that. And if I wanted to give it away when I spoke, I wouldn't be able to do that. So the third book I published on my own, and I wanted to do it on my own because I now understood that the money and a lot of the opportunity that came from publishing wasn't the money you made selling the book, even at a discounted royalty rate, that I got from the ABA. Even if I got all the royalties, the benefits were to be able to give the book away and to use it sort of as a lead generation tool.
Right. And that gets back to what is the publisher going to do and what are they going to allow you to do? Because you're creating an understanding among potential customers that you have subject matter expertise in this area. And whereas a book that's less than $100 might give you some royalty stream, the bigger royalty stream is, a multi-day boot camp or something else
Mm-hmm.
where you're really doing on-the-job training for people who want to dive into the details of the things that you cover in the book, but then walk away with the book, which they can use in the future as a reference tool. And that's
Right.
something that you really need to understand as an author. What is your business plan with the content, short-term and long-term, and making sure that that business plan is consistent with what you've agreed to do with the publisher. And that gets to a point, reversionary rights to the author. So one thing that people should consider if they have the power to do so is if a publisher is unable to sell over a certain number of books or put a certain amount of marketing muscle into a product over time, and there's some clear deliverables that they have to provide as the publisher of the book in return for the benefit of getting that content and getting a major revenue stream from the sales of the book, there could be a clause within the contract where the rights revert to you so that you can go out and market and do things of that nature. And that's something that many publishers will consider, because a lot of traditional print publishers realize that with some material, it really is dated content. And if they have obligations to you to continue to use marketing money on your product that they could be using on new, fresher products, it actually makes a lot of sense for them to pay perhaps a little less money for the upfront payment in order to obtain the copyright, or actually get a little greater royalty stream out of the relationship with the knowledge on both sides that the rights can go back to you as the author, and you can do with it what you will when they decide it's really not useful content for them anymore.
Mm-hmm. Yeah, the first couple of years that I was selling that I had two books out there with the ABA. I think the top year I grossed or got, I want to say like $6,000 in revenue. And then so it's been a couple of years, and then last year I got my royalty check in December, and I eagerly opened it up thinking maybe it'll be a couple of $1,000s this year. No, it was like $347. And it's very clear that they're doing nothing to market it, which is fine. I understand that. I'm not complaining about it. But, I'm at the position where I have a PDF copy of the Acrobat book. I do a lot of training of teaching people how to use Acrobat. And it would be really nice to say, well, just open up my book in Acrobat because it's a PDF and let's work through it and see how to learn these things that I'm trying to teach you. I've never approached the ABA to ask them if they would relinquish the rights. Maybe they would. I frankly just don't even want to go through the tedium of doing that. I created that other book. It's talks about how to use Adobe Reader. It is a PDF. I teach people how to use that. And then if they reach the point where they've learned enough, I say, go on to the Acrobat book and buy that one. But yeah, reversionary rights, I didn't think about that one and I wish I had.
So, since you're talking about digital versions of the books, this leads into another interesting topic and some more traps for the unwary author. So, it's very popular now to hire a designer to create a digital ebook. And they use these fancy software programs to design the layout. They may have special fonts, certain colors that they use, and they can offer a really interesting, visually stunning version of an ebook for you that you then market and sell or give away for free as an add-on to other services that you provide. But there's a number of things that you need to do with these ebooks that people forget about or they just don't know about. One is the fonts that the designer might use. They may be using fonts that involve licenses that have to be obtained from Adobe or whoever has created the fonts. And people don't realize that. So they might hire a designer for, frankly, a lot of money to design the layout of the book for their content. But the designer may not have the license to the font that they're using, or they may have a license that they purchased in the past, but they can't transfer that right to you under their contract with you. So you might say, well, why does this matter? Who cares? Well, the answer is these font creators or the parties that have the licenses they now have pretty sophisticated programs and technology and people where they're going out and looking for their special fonts where people pay sometimes thousands of dollars to obtain a license. And if they see a version and they don't have any information in their records regarding that content and a license to that, you might actually receive a cease and desist letter and an offer to license that font for an amount that's far above what you could have licensed it legally for in the first place. And also, frankly, in these letters, you usually get a request for the attorney's fees associated with their time and effort to investigate this issue. The same can go for other aspects of the layout, including the photos that are used. So when people are working with designers, they should understand, are they getting original illustrations that the designer has created? Are they getting stock photos? I certainly hope not. Are they getting stock photos that have been modified? And if the designer is using images that is not the designer's original content, you need to make sure in your contract with the designer that the designer is getting the necessary licenses and is transferring the necessary licenses to you as the author and owner of that content. Because again, the same issue can happen. You can get a letter from Shutterstock or somebody else saying, Getty is a famous example. Getty has a significant licensing and enforcement program, and you might get a letter from one of these companies, and if you can't produce evidence of your license, you can have a problem. So if you use designers, it's really critical that you make sure that they're getting the licenses that are needed and that they're transferring those licenses to you. And in fact, frankly, you should get evidence of those licenses, because it may be 5 years down the road and the designer's long gone and you don't know how to contact them. but Getty's knocking on the door, or Shutterstock's knocking on the door and saying, give me evidence that you have a license to this content.
Yeah, I didn't think about that too much. I did know that I needed to use original images. I didn't, most of it was screenshots, and I had permission from Adobe to use those. But the graphic was done by a designer. It was original. That's the cover. So that was the only thing that was different. But yeah, I guess I didn't think about that. So that's good advice.
Another thing I find with designers is they want to keep the copyright to all of the content that they create, including themes. And it can become quite an emotional battle. I see it over and over again with our authors when we're trying to do these clearance searches for them and they're working with designers. So some people say, oh, okay, well, we'll let the designer keep the copyright and I just want a license. But people need to be careful about this, because imagine if the designer you paid a lot of money to creates a really cool layout for you with a certain position for the text and certain colors and certain fonts. And then you turn around about a year later and you see that they've done something similar for another company that may or may not be a competitor. You may have given them the rights to do that, to basically reuse all the design layout that they created for you and use it for another company. So that's no fun for people
Yeah.
when they figure that out. You paid for original design that works for your content. And so this is part of the conversation that people need to have with their designers to make sure that the compilation of the design that has been created is yours. Now, the designer may want to have a license to use that design in their marketing materials or on their website, right? To show people the cool work that they've done. And I see that commonly. And, we support that with clients, let the designer continue to be successful. They get what they want, but they're not reusing the content with other clients. But that's another issue that arises. Who owns the copyright? And generally, it can be quite problematic if the designer owns the copyright to the compilation, because what authors can do unwittingly by giving them that copyright is they've actually given the copyright over to the content that they've created and put in this digital ebook. And I have yet to meet an author who intended to do that when they hired a designer and negotiated the agreement with the designer.
Right. Yeah, I hired my designer through Upwork, and I've hired other folks through Upwork, and it's kind of a free for all there. And I think it's a lot of loose thinking, and people just scrambling to do the job quickly and efficiently and get a good rating and get paid. Fortunately for me, I didn't have many of those issues, and the ones I had, I took care of. But yeah, that's pretty sobering advice, which I will definitely think about the next time I go out to get a designer or somebody to work on my book.
So, Ernie, we're at the segment of the show, what we've learned and takeaways. And I guess we've been doing what we learned and takeaways the whole time. But, what I'd like to hear more about your efforts as you've created more content over times. What are your war stories? What have you learned along the way, given what you do and how you do it? And perhaps this is really a question of, if I could go back and do it differently, how would I do it?
Yeah, I think the biggest thing I learned is that there are people who publish books not with the expectation of making any money off the book whatsoever, but rather using it as a lead generation tool. And in that situation, you want to have complete control over the book if possible. And I just came from a 2-day conference in Texas where it was a bunch of mostly pro bono type lawyers, folks who didn't have a lot of money. And one of the things I talked about was using PDFs. And in the course of talking about it, they said, oh, you've got a book and it's available for $14.95. And I realized at this point, these are people that really, me charging them $14.95 wasn't going to make me happier. And some of them weren't going to buy it because that was just too much money. And I just said, you know what? I'm going to give everyone in this room a copy of the book. Just shoot me an email. I'll be happy to send it to you. And I didn't have to think twice about that. But if I had published it through somebody else, I would have to think a lot more than twice. And I just don't think for many people who want to publish a book, that's the road they want to take. You have to think through what's going to happen after you have published this book. What are you going to do with it? How can it benefit you? And I think it helped the ABA when I did those books, but I don't think they're interested in anything having to do with those books now. And I wish I had not given them, rights for the full extent of copyright.
Well, so Ernie, this brings up an interesting question relating to piracy. Now that you're offering digital versions of your content, are you seeing piracy? Are you looking for piracy? And what are you doing about it?
That was one thing I kind of fretted about because I didn't know how to sell stuff online when I was going to publish the book. And, I didn't know, like, how do I protect this content? And there were ways to do it, but they were kind of cumbersome. And in the end, now I do have it. You have to give your credit card and then you can download it. And the link only works once and stuff like that. But I really don't worry about piracy because I'm not trying to make money off of every sale of the book. The book is a way for people to get to know what I'm all about, to see that I have good advice, that I've thought through how they should work with PDFs if they're a lawyer. There's no other books written by lawyers for lawyers about that kind of thing. And I have other products that I sell that are more expensive, like the 2-day live seminars or the online course. So the folks that buy that book or that get the book by hook or crook, they will figure out who I am. And I kind of follow the Seth Godin model. He published a book called The Idea Virus, and he recommends following the path he took, which was he wrote the book, gave it away for free, and like a virus, it spread all over the place. And that's how he became well known. And every book he sold after that was easy to sell because a lot of people knew who he was.
So that's interesting. Because of your business model, piracy actually can work to your benefit. I'll call it piracy, but really
Yeah.
you don't want to restrict people's ability to transfer it to others and share it and things of that nature, compared to somebody who may make their living off of selling these ebooks and other digital content. And for them, if there's a website that's set up where somebody is offering that content at half price, that's obviously has the potential to cut into their own sales. And so they might want to use something like the DMCA notice and takedown provisions to get that site down and get that content down. So I guess it really depends on the business model. And this is a
Right.
philosophical discussion that every content creator needs to have in their head or with their colleagues, whoever is part of the business in creating this content, to understand what the business model is and whether it's better to allow people to freely share that content. And so you really don't want security barriers, watermarks, things of that nature to protect against use and sharing of that content, or whether you do, because it's the transfer of that content itself that actually creates your revenue stream.
Yeah. Yeah, for some book I might write down the road, I might want those things, but for right now, the books I've written, I mentioned Seth Godin. Another analogy would be it's like the 1960s rock band, the Grateful Dead. They let people come to their concerts and tape the music, and through that sharing of the tapes and that community that got built up, that made sense for them because more people would show up at the live events and more people would buy the albums. And that's my model. There's the other models, but that's the one I like. So that's the one I use.
Makes sense. Sounds good. Well, Ernie, thank you for sharing your war stories as you develop content with the ABA and your own digital content. I want to close by making sure that people can contact both of us on Twitter. I'm Antigone Peyton, you're Ernie Attorney. But I also want you to share more information about your current venture and let people know where to find you and how to contact you, and give them a little more information about what you're working on now.
Sure. Well, I have two websites and multiple Twitter accounts. So my personal account is Ernie Attorney. That's my Twitter account. And then my business Twitter account is Paperless Chase, which is a play on the movie Paper Chase, but it's Paperless Chase. And the website for that is paperlesschase.com. And then more recently, I created a website that is more broadly helping lawyers develop their practices beyond just being paperless. And I call that one smallfirmbootcamp.com. And there's no Twitter feed for that, just the website, smallfirmbootcamp.com.
So what are you doing on smallfirmbootcamp.com now?
That is really helping lawyers figure out how to make their practices easier to manage by using technology in a systematic, sensible way. You know, a lot of what I learned about technology, I learned in a sort of haphazard way, and then I turned around and taught it in a haphazard way because that's how I learned it. But I've learned from doing this more often that people want a roadmap. They want to kind of know, okay, from here, what's the next step? And I'm at level one. How do I get to level two? And so I spent a lot of time thinking about that and created an online course for that. And that's what I do now is I have an online course. It's available on smallfirmbootcamp.com. You can go there and take the first 3 lessons for free, see if you like it. And if you like it, keep going. And then if you get into that world, you might decide that you want to come to one of our 2-day boot camps, which we do once a year in New Orleans, where it's fun and there's good food and good merriment.
Excellent.
Yeah.
Thank you, Ernie. Well,
Yeah.
thanks for joining us, and thanks to our listeners. If you want to join us for our next show, we do it twice a month. And Ernie, thanks again. Appreciate the information. It was fun to talk about your content.
You're welcome. Thanks for having me.